In 2020, Black Lives Matter protests opposing police brutality and systemic racism rightfully swept the nation. The demonstrators recognized that time and time again, Black and Brown communities experience horrific violence at the hands of law enforcement with virtually no accountability for wrongdoers. This state of affairs is a direct result of two legal doctrines created by the Supreme Court that have been changed beyond recognition: qualified immunity and the Bivens doctrine.
Qualified immunity is a legal doctrine most commonly associated with police officers that shields state and local officials from lawsuits seeking to hold them accountable for violations of the Constitution. Qualified immunity is a powerful defense that officials raise to protect themselves from legal repercussions.
In 1871, Congress passed the Civil Rights Act and established the right for ordinary people to hold local and state officials accountable in court for constitutional rights violations. This law was passed in direct response to the terror inflicted on Black Americans by state officials after our nation's Civil War. Today, the Supreme Court has all but eliminated this right, and the resulting police violence that falls most heavily on Black and Brown communities is in direct contradiction to the intent of the Civil Rights Act. Over the past several decades, the court has defined qualified immunity in a way that has made it virtually impossible to hold officials like police officers accountable unless their victims can point to a specific court case that outlines a clearly established statutory or constitutional right. But what exactly does that mean?
Well, the term clearly established, as the Supreme Court has come to define it, sets an incredibly high bar. Essentially, police officers using excessive or unreasonable force can escape liability unless a court has previously found an officer liable in a nearly identical factual situation. This rarely happens in real life, and while qualified immunity is perhaps best known for applying to police officers, its sweeping protections allow other government officials to escape liability as well.
Qualified immunity has operated to protect law enforcement, even in egregious circumstances. For example, in 2020, an officer was granted qualified immunity after shooting a boy who had raised his hands and dropped a BB gun.
Cleared of any wrongdoing in the shooting of a 14-year-old in Battle Creek.
Similar protections against accountability exist for federal officials as well.
Unlike for state actors, there is no underlying law like the Civil Rights Act that gives people the right to sue federal actors. In fact, it wasn't even until 1971 that any general standard even existed for holding federal officials liable in civil court. That year, the Supreme Court decided Bivens, which is a landmark case that held that people could bring civil suits against federal officials for violating their Fourth Amendment rights. And this holding was then later extended to violations of the Fifth and Eighth Amendments as well.
Press! I'm pressed! Here, get down! I am pressed!
But these few cases where liability was found would prove to be the exception, not the rule.
Since the decision was issued, federal courts have overwhelmingly gutted the Bivens doctrine, declining to extend liability to any new context or new category of defendants.
As a result, horrible violence has gone unpunished. In February 2020, in Hernandez v. Mesa, the court ruled that the parents of a Mexican child shot and killed by a United States Border Patrol agent could not bring a Bivens claim because the cross-border nature of the violence represented a new context. Legal experts from across the ideological spectrum have criticized this state of the law for resulting in a lack of accountability for law enforcement. Supreme Court Justice Sonia Sotomayor once described qualified immunity as an absolute shield for law enforcement officers. With the current state of the court's jurisprudence, it is clear that Congress must act. The doctrine of qualified immunity must be eliminated through legislation. And, at the same time, Congress also must pass a new law giving people the right to sue federal officials for violation of their civil and constitutional rights. Our civil liberties are dependent on it.